hearing, it was before Justice Aniruddha Roy. And my lord, matter is very simple. No money is provided, but acquisition has been made previously, and hearing was given to me, but they said that no, we have already said that you have been paid. But that is a false statement, and we have challenged that by a second writ petition. That is the reason why, my lord, matter was due to appear in July month.
Writ petition 2022.
Yes, my lord.
I have
22.
determination up to 2022 only.
22, yes, my lord.
For listing. Okay.
I'm extremely grateful. Hearing, my lord.
My lord, under compelling circumstances, my lord, I'm mentioning, my lord, remember, my lord, on 17th June, my lord was pleased to reserve the order, my lord, on 17th June, my lord, for Sirajuddin, my lord. My lord, I am the appearing on behalf of the NHI, my lord. My lord, lordship, kindly visualize my predicament, my lord. We need a encumbrance-free land, my lord, for completion of the project, my lord. If your lordship kindly, my lord, pronounce the order.
It is ready. It is ready.
I'm so kind of your lordship, my lord. We are suffering, my lord.
Within the next week, it will be good.
I'm so kind of lordship. Can I serve?
Not necessary.
I'm so grateful to you,
It
lordship.
is ready, I think.
So grateful to you, lordship.
My lord, may I be permitted to mention, my lord, for inclusion, motion, my lord, 2016.
2016 land matter.
Yes.
My lord, may I be permitted to mention for inclusion 2021 land matter?
Lord, may I have your kind leave, my lord, to mention the item number 2 today. My lord, I'm mentioning today a bit of embarrassment, my lord. My lord, had been fixed this matter today at 3 p.m., my lord. Item number 2, my lord. My lord, I'm for the respondent authority, my lord, IOCL. My lord, I'm led by Mr. Amit Kumar Nag, my lord. My lord, he has some personal difficulty today, my lord. I'm only praying for a short accommodation, my lord, today.
Who is for the petitioner?
My petitioner is here, my
That
lord.
been fixed at my instance, my lord. Since it's personal difficulty, I'm not standing in the way. However, if lordship be pleased to fix on some other day, because Thursday and Friday, I understand, my lord, the group 8 matters have not been taken up. So the only possibility, if your lordship be kind enough to fix it on Monday at any point in time, because there is some urgency.
Not Monday.
Any
Monday
day-
I have fixed already. On mentioning the matter, item number 2. On mentioning this matter be on mentioning by the learned counsel for the respondent, the matter be listed on 30th of July 2025 at 3 p.m.
Grateful, my lord.
Next.
My lord, application for recalling application, due to non-appearance of behalf of the petitioner, the petition was dismissed for non-prosecution and the petition was dismissed on 13/6/2005.
When it was dismissed?
30 July 2025.
30th of July, June
25.
2025. Okay.
Your Lordship, may I be permitted to mention a matter regarding inclusion of a CAN application regarding a land matter. This is a matter about lease property, and my client's leasehold was illegally terminated, Your Lordship, and someone with a similar predicament was allowed to build a structure with a fine.
What is about the can?
Yes, Your Lordship, this is a CAN
For
regarding
what?
CAN for Your Lordship to have the similar to heard the similar prayer by the KMD, Your Lordship, to let my client build his structure, although he has passed the stipulated time, but his leasehold property was illegally
Have you
terminated.
served before
Yes, Your
mentioning?
Lordship.
Before mentioning, have you served?
Yes, Your Lordship. It has been served, Your Lordship. I'm grateful, Your Lordship.
Item number 9 of today's fixed. 9.
Yes.
But the order is going to be expired tomorrow, but difficult is that there is a page have to clear.
Yes, I have a division bench there.
So what the is that here, ask me, I can bring you at 1:50 or 1 p.m.
Very common. That.
Okay.
Call the list.
For the respondent, I talk now.
Order.
Abhijit Kaur Modok
Right.
versus Indian Oil Corporation Limited. I am reading only operative portions.
My lord.
Under the above observation, I am of view that act and action of the respondent authority in passing impugned reason order is arbitrary. The respondent authority has not properly complied with the direction of the Honorable Division Bench. In deciding the prayer of the petitioner for reconstitution, they also flouted the terms of the guideline for reconstitution of LPG distributorship by confusing themselves in the earlier conduct of the deceased father of the petitioner. Under the above observation, the instant writ petition appears to be meritorious. The impugned reason order dated September 11, 2024 by the respondent authority is hereby set aside. The respondent authority is directed to pass an order of reconstitution strictly in terms of guideline and to convey their consent regarding allowing petitioner to run the distributorship license within 6 weeks from the date of this order.
Much of
Writ petition disposed of.
it.
Next.
Right?
না 11 একটা 11 বলো কেন?
আমাদের But item 11, 12, 13 and 14 also are same issues are involved. My learned friends appearing in item number 14.
14 is my repetition, my lord. So it's similar.
Item number 11, 12, 13, 14.
My
I am appearing in 14, my lord.
You are appearing
same
14.
issues them.
Issues are same.
Yes, my lord, if you also kindly take up
11,
item
12,
number 12 first.
Item number
I'm
12.
confused actually with what. My video of my learned friend is appearing. This matter is to some extent already considered by your lordship in a previous proceedings. I shall bring your lordship notice to all the orders.
Yes.
The petitioner before your lordship is the LPG distributor of Hindustan Petroleum Corporation Limited. But he has been engaged in the year 1985. And thereafter, after 5 alternative years, the agreement has been executed, rather renewed. The last such agreement has been renewed on 28th of April 2025, which will appear from page 38. Page 38 is the last agreement executed by and between the oil company and the petitioner before your lordship.
Page?
And page 38. Then, my lord, in the year 2018, 3 oil companies issued 3 circulars. That is called restructuring of customers or transfer of customer circular. So far BPCL and IOCL is concerned, my lord, they have issued the circular on 4th of January 2018. And so far Hindustan Petroleum Corporation is required, my lord, they have issued it on 9th January 2018. The circular says, my lord, transferring of customers from the existing distributors who have been appointed prior to 2016 and give it to the newly appointed distributors. But this circular has been challenged before the Bombay High Court Division Bench, interfered with. If you lordship kindly straight away come to page, my lord, 66. All the points have been considered, including the point of maintainability, arbitration, agreements, clauses, all have been dealt with. Page 67 starts, Division Bench judgment. Kindly see the name of the, page 66, the name of the petitioner, Mrs. Shoiloja Khanbilkar. But the order in its lordship, step kindly come to the order in portion. The challenge was at page 68. Kindly turn to page 68. What was the challenge in the previous version? Page 68, first paragraph I am reading. This writ petition impugns the circular dated 4th January 2018. Well, this is against the BPCL. They have issued the circular on 4th of January 2018. I have already submitted. And so far, my oil company is concerned, that has been issued on 9th of January. So,
9th of January.
9th January. So far, HPCL is concerned. I have annexed both the circulars.
Yes.
Well, kindly read my first paragraph. This writ petition impugns at page 68 a circular dated 4th January 2018. This is the restructuring circular issued by the Bharat Petroleum Corporation Limited. Response number 3 and communication dated 13th March 2018. This is the communication whereby customers have been transferred. Kindly come to my page 107, the operative portion. All the points have been dealt with, my lord. Your lordship has already gone through this judgment and delivered a judgment on the identical issue. Page 107, kindly turn to my lord, paragraph 24.
Yes,
It was Mr. Sanchez's last argument that in the absence of any case that the improved circular is arbitrary or suffers from unreasonableness, the challenge of the petitioner to the improved circular cannot be sustained. For the reasons set out herein above, this argument holds no water since we have already held that the improved circular is arbitrary, irrational, and in the least violates the petitioner's right, vested right, who is providing so and so. For the reasons aforesaid, the petition is allowed in terms of their so and so, in terms of communication, cost and set aside. But both the communication. So far the circular is concerned and the curtailment is concerned, both has been cost and set aside. Now kindly turn the page, my lord, next page. The oil company preferred an SLP before the Honorable Supreme Court, and in that SLP initially they have filed an application for withdrawal, and the next day another application to allow them to withdraw the withdrawal application. It starts from page 108. Kindly turn to my lord, page 114, the order in portion. So this SLP is still pending. Supreme Court did not interfere with that order. Kindly read, my lord, application for withdrawal of the earlier application. For withdrawal of the SLP is allowed. Two applications, first application for withdrawal, then application. My lord, this matter is still pending. Supreme Court did not interfere with the order of the Honorable Division Bench of the Bombay High Court. Kindly turn the page. Other court. This is an order passed by the Madurai Bench of Madras High Court, page 115. Same issue. By state, by different high courts. Same circular, state by the division bench high court. Provision for the I shall take your lordship to return back all those customers at this rate, at this day or not to delink any other customers, transfer any other customers. But this is a fit case where, my lord, at the first day, your lordship and quash and set aside the circulars by directing them to transfer all the customers.
So impugn order dated 160 and 161.
My lord. 160 and 161. These are the two. This is after taking away intimation. I have taken away, I have transferred. Possibly this is a fit case at the first stage, your lordship might quash and set aside both this notification and directing them to return back. While there is an existing interim order, in a previous proceedings, Mr. Bishop Chakraborty argued before your lordship can remember that this is not in the state of West Bengal. Your lordship and Justice Distributorship also held this is a ridiculous submission that Bombay High Court passed an order which is not applicable to the state of West Bengal. That portion I can show to your lordship from Justice order passed by Justice Vivek Chaudhary.
Yes, I know that.
My lord. So these are my submission and possibly my lord the same submission almost. Yes. Let me know.
This circular has been challenged is by the 3 oil marketing companies. I presume I am only appearing for one of the oil marketing companies. The other 2 oil marketing companies presumably have not been either served or intimated, my lord, because this circular is having a ramification, my lord, for the 3 oil marketing companies throughout India, my lord. There are judicial pronouncements by various high courts, my lord, which has been carried to the Honorable Supreme Court, my lord, of the earlier circular, my lords, and the Honorable Supreme Court has declined to entertain such proceedings or special leave petitions from the High Court order. My lord, those High Court orders or judicial pronouncements passed by various High Courts, Punjab and Haryana High Court, by the Kerala High Court, Ernakulam bench, my lord, has not been considered in these orders before, my lord, which has been placed before my lord today. And my respectful submission is that, my lord, this particular scheme, which has been promulgated in 2025, my lord, as has been placed by my learned senior friend, my lord, is in digression from the existing circular, which was in 2018, my lord, because there are certain issues involved. So, my lord, I'm humbly beseeching, my lord, if the other oil companies are also intimated by the petitioners, because this circular is being challenged, this circular is having a ramification for the entire country. And there are judgments, dissenting judgments, which has not been considered by the various courts, and by these judgments which has been placed before my lord on behalf of the petitioners today, my lord. So, my lord, the Indian Oil Corporation is not being implemented. My lord, I presume for Bharat Petroleum Corporation, nobody is appearing today.
No, you are appearing for whom?
My lord, I am appearing for only Hindustan Petroleum Corporation Limited.
So, in this matter, what is your submission?
My lord, in this matter, my lord, I will place my submissions, my lord, subject to my lord, my learned friends completes the submissions. My lord, the petitioner in item number, my lord, item number 14, the petitioner is appearing, my lord.
Yes. Item 14 is my petition, my lord.
So, item 14, you are also there?
My lord, item 14, I am not appearing.
Item 14, my lord.
Against HPCL?
BPCL.
BPCL.
Whom I have served, and I'm carrying my affidavit of service.
My lord, let the applications be served to the oil marketing companies, my lord. Other Indian Oil Corporation is the main, my lord, oil marketing company in India, my lord. Thereafter, the other oil marketing companies definitely are there, my lord, because this circular is having a ramification throughout India.
No, what is your submission in this matter?
Yes, my lord. My lord, I will place my submissions first. Let me, if my learned friend doesn't place his submission, it's okay.
You are not there in, not party in their matter.
Yes.
You are party in this matter. So,
Yes,
you submit what you want to submit.
My lord, firstly, my lord, my initial submission before my lord today is that there was an order which has been placed before my lord concerning the earlier circular where the honorable single bench of this honorable court, my lord, has passed an order wherein the circular was set aside. My lord, if my lord kindly takes page 129, my lord, page 129, my lord, is the portion of the order which has been placed before my lord, and page 123. My lord kindly takes first page 123 of the order. in one of the writ petitions by Messrs CLS Limited, my lord.
Yes.
My lord, in that particular matter, if my lord kindly sees, the observation is that for existing distributors, the oil marketing companies fixed formula wherein refill sale in excess of 75% of the ceiling limit would stand
You are reading page 123?
My lord, I'm reading 123, the first paragraph, my lord.
Okay.
My lord will kindly sees for existing distributors, my lord, from the 10 lines, my lord. For existing distributors, the oil marketing companies fixed formula wherein refill sale in excess of 75% of the ceiling limit would stand transferred to the new non-performing distributors to achieve purported market viability of 50% of the ceiling limit for such new non-performing distributors. My lord, this particular observation, my lord, which has been there, was there in the earlier policy. My lord, the new policy, my lord, which has been in 2025, my lord, envisages the fact that the existing distributors, who is the donor distributor, my lord, he's the donor distributor and the recipient distributor. My lord, a customer is basically of the oil marketing company. The right which the oil marketing company exercises on the customers, my lord, the distributors cannot exercise the right on the customers. My lord, this 75% has been changed to 100%. My lord, the new circular, my lord, which my lord kindly sees, which is impugned in the writ petition, my lord, at page 2025, my lord, at page 151, my lord, where my lord kindly sees, my lord, this particular ceiling limit has been taken to 100%. My lord will kindly sees page 152, my lord. All the donor distributors will be retained at 100% of the refill ceiling limit applicable to them as per the table given below while undertaking customer transfer. My lord, my respectful submission is that
donor distributor will be retained at. What does it mean?
My lord, it means that a donor distributor is the distributor from whom the customers are transferred to a new distributor, a distributor who's basically not performing that well. My lord, the actual situation or the rationale behind the oil marketing companies coming up with these circulars is because to stop cartelization and to stop, my lord, monopolistic attitudes in the market of the distributors. My lord, basically the customers or the consumers are the prime benefits recipients from the oil marketing company, while the distributors are intermediaries. My lord, this particular clause means that the donor distributor is a distributor from whom the customer base is shifted, my lord. He will be retained with the 100% of the customer base. Until and unless he retains the 100%, customers will not be removed. My lord, this was not there in the previous circular. What has been placed before my lord today is that this circular in 2025, February 2025, is a direct replica of the earlier circular. With my respectful submission, my lord, this is not correct. My lord, the circular which has now been promulgated is that the donor distributor or the distributor from whom the customer base is getting shifted has to be achieving 100% viability. There cannot be any removing of customers until and unless the donor distributor or the distributor from whom the customer base is shifted is achieving 100% viability. This was not there in the earlier circular. There was 75% ceiling limit, as has been observed by my lord Justice Chaudhary in his order, my lord, in page 123. So, my lord, what has been projected before the Honorable Court, my lord, is that there has been an infringement in any of the provisions of the Constitution of India, Article 19(1)(g), Article 14. These are the provisions, my lord, which there has been right to profess, practice, whatever business, etc. My lord, my respectful submission today is that there are various judicial pronouncements of the Punjab and Haryana High Court, of the Kerala High Court, which upholds the circular of 2018, which upholds the concept of transferring of customer base from one distributor to another. My lord, I will place these various judgments.
The earlier circular.
My lord, the earlier circular. My lord, the concept, my lord, I am placing before today, my lord, we are all before my lord today, placing the concept of transferring of customers. What the orders which has been placed today before my lord is that the customer base transfer has been restrained by certain high courts. But I am also placing reliance on certain judicial pronouncements, my lord, wherein my lord transfer of customer base has been upheld. My lord, secondly, my lord, my respectful submission today is that the LPG manual, my lord will kindly seize, my lord, the agreement at page 38 of the writ petition. My lord, this is the dealership agreement which the oil marketing company executes or rather with the dealers.
Yes.
My lord, clause 2 at page 39, if my lord kindly sees. the corporation reserves the right, without any reference to or consent of the dealer, to appoint one or more additional dealers in the same territory referred to in clause 2A above, and such additional dealer or dealers shall be entitled to make sales of HP gas in the same territory without any objection from the dealer, and the dealer shall not be entitled to claim any overriding remuneration, commission, or allowance for the purpose. But this particular agreement is signed at the bottom by the concerned distributor.
So what does this clause mean?
Now, this clause means that the corporation, that is the oil marketing company, reserves the right to appoint any additional dealers.
Yes.
Malad, in this particular situation, the customer bases are getting shifted. So there are other dealers
Where
which.
is the clause regarding shift of customer base?
Malad, thereafter, Malad will kindly seize the next paragraph, Malad. Without prejudice to the above, the corporation shall be entitled to require the dealer to effect minimum sales of HP gas in accordance with the policy that may be formulated from time to time by the corporation, and shall further entitle at its sole discretion to reduce, restrict, modify, or alter the area of the dealership territory.
Yes.
And yes, Malad, this area of the distribution territory is concerning the customer base. Malad, once I am reducing the territory or I am enlarging the territory, I am either bringing in more customers or I am reducing the customers. Well, the territory base area is connected with customer base. My respectful submission before my lord is today.
No, where is the customer base? You can modify the area. You
Yes,
have the
madam.
authority.
Yes, my lord.
So you have given you have agreed with a
Yes, my lord.
with a distributor that you must perform business within the Calcutta.
Yes, my lord.
But thereafter you Calcutta and Howrah, and
Yes, madam.
thereafter you can curtail it. Calcutta
madam.
separated to the Howrah.
Yes,
But
madam.
there is no such
My
bar.
lord, cutting the territory also has a repercussion on the customer base, because if I am moving out Howrah from a particular distributor, the customer base gets reduced, or customer gets
That
transferred
is
to
the
some.
provision
My lord,
that you can take away the customers.
My lord, that is having a cascading effect on the customer base. My lord, if my lord kindly sees or reads, my lord, for once again, my lord, if I am reducing or increasing the territory base, or if I am appointing additional dealers, my lord, in that event, my lord, the customer base either increases or decreases. Because my lord, the area of a territory, my lord, is connected with the customer base. My lord, area, geographical area has no meaning in these sort of dealership agreements. My lord, my respectful submission before my lord today is that the territory area is also connected with customer base. Furthermore, clause B says the additional dealers can also be appointed. My lord, additional dealers is a fact that you can also appoint an additional dealer to an existing customer base of a distributor. It has been repeatedly held by various high courts, my lord, that the distributor does not retain a right over the customers. It is the oil marketing company who is connected with the customers. The distributors is an intermediary between the customer base and the oil marketing company. It is for the beneficial situation for the customers, my lord, that the oil marketing company is coming up with these circulars to reduce monopolizations of the distributors. My lord will kindly takes, my lord, thereafter, my lord, the distributorship agreement at page 42. My lord, clause 12.
Clause 12.
Yes, my lord. My lord, clause 12, my lord, says the dealer shall faithfully and diligently observe and carry out all directions, orders, terms, and conditions as may be issued by the corporation from time to time, and may be contained in the corporation's HP gas manual, and any amendments or modifications as may be made by the corporation thereto from time to time. The dealer hereby confirms that he has received a copy of the HP gas manual and the general directions as circulated by the corporation on the date this agreement, and agrees to abide by and perform the same. Mother, I will demonstrate from the HP gas manual. Mother, there is the concept of portability of customers or transfer of customer base from one distributor to another distributor. My lord, may I place, my lord, the HP gas manual once again? My lord will kindly takes the HP gas manual. My lord, I have a copy, my lord. Yes, absolutely. My lord, I will place, my lord, from the HP gas manual, which is a part of this agreement, my lord, clause 4.4 at page 56, my lord. If my lord kindly takes page 56, my lord. My lord has seen, my lord.
Yes.
The distributor to enroll customers within the authorized area only as per distributorship agreement and approved by the corporation writing to ensure viability of the new commission distributorship, refill sale limits, better customer service, etc. The OMCs may increase or decrease the area of operation of the distributors from time to time, and the distributor is bound to surrender, transfer, accept the customers. My lord, we kindly sees, my lord, in this particular manual, which is a part of the agreement, and the dealer or the distributors have signed this particular agreement, knowing fully well, my lord, they can at any point of time, my lord, these particular aspects were not considered in the judgments, my lord, which has been placed before my lord today. My lord, my respectful endeavor and submission before my lord is that these particular aspects has not been gone into by the honorable courts. Furthermore, my lord, I will also rely on other judicial pronouncements by the other high courts, which had been carried to the Supreme Court, and the Supreme Court has not entertained on this concept of customer transfer. My lord, firstly, my lord, I will further rely to ensure the viability of the new commission distributorship, refill sale limits, better customer service. The OMCs may increase or decrease the area of operation of the distributorships from time to time, and the distributor is bound to surrender, transfer, accept the customers. The distributor is not allowed to appoint, operate sub-distributors. This is the first clause which I'm relying, page 56. Thereafter, I'm relying on clause 4.6 at page 57. My lord, clause 4.6, my lord.
Yes.
My lord, customer transfer. As per OMC directions, the distributor is required to transfer the customers on inter-company basis in line with the prevailing policy guidelines. My lord, my respectful submission before my lord once again is that the policy guidelines which has been promulgated by the 3 oil marketing companies in consultation with the Ministry of Petroleum and Natural Gas, my lord, is in consonance with this particular LPG manual, in consonance with the agreements executed by the distributors. So it was from the very onset, my lord, it was within the knowledge of the distributors that I do not exercise any right over any customer. My lord, there is no indivisible right, my lord, which has emanated in favor of the distributors over and above the oil marketing company. My lord, thereafter, my lord, I'll rely on clause 10.4, my lord, it is at page 84. If my lord kindly takes page 84 of the LPG manual once again. My lord, 10.5, my lord, if my lord kindly sees. At page 84, the last paragraph, my lord.
10.5.
Yes, my lord. My lord, portability of LPG connections. LPG consumers have been given the choice to switch from their old distributor to another better star rating distributor within the cluster as per their choice within and across the OMCs. The objective of introducing portability was to provide customer greater choice to select his distributor and to bring competition among distributors. The portability request is made electronically and completed without manual intervention. The customer has following value added
of the customer.
My lord, that is the choice of the customers. But my lord, my respectful submission today is that this particular concept is not a new concept, but this particular concept has been there in the agreements executed by the distributors, executed by the petitioners before my lord today, my lord. They had been aware of this particular concept of customer transfer from one distributor to another, my lord. And the agreements has been executed. It is supported by contractual clauses, my lord. They have signed it, my lord. My lord, thereafter, my lord, I will be relying on 2001 SCC online Punjab and Haryana, my lord, 1403. My lord, I am just placing my lord's copy. Malad, this is 2001 SCC online Punjab and Haryana 1403. Malad, here also the issue 2001 SCC online Punjab and Haryana 1403. Malad, this is also a division bench judgment of the Punjab and Haryana High Court, Malad. This is not in connection with the earlier circulars, Malad, or on the concept of portability or transfer of customer base from one distributor to another, Malad. Malad, in this particular matter, Malad, if Malad kindly sees LPG distributorship closure of extension, Malad, may I rely on paragraph 15, Malad? Has Malad seen, Malad? Paragraph 15, Malad.
Yes.
Admittedly, guidelines have been laid down for appointment of distributors. Detailed procedure has been prescribed. There is a survey for identification of the location. Then there is an advertisement and selection. The dealer is appointed for an area. Specimen copies of the letter of intent, appointment, and agreement were produced by the Council for Hindustan Petroleum Corporation. These were taken on record as Mark A. In the letter of intent, the area of operation is specified. While appointing the dealer, the trading area is clearly defined. To illustrate, in paragraph 3 of the letter of appointment has been stated that the area of operation will be within the municipal limits. Even in the agreement, the areas within which the distributor shall distribute the product is specified. Still further, it has been also provided that the area is subject to change as may be considered necessary by the corporation at a later date, even after the distributorship is commissioned. The appointment letter further stipulates that a particular distributor may be required to take over some existing customers of other distributors. Similarly, you may be required to surrender some customers to other distributors. A perusal of these documents clearly shows that the area of operation is specified. There is no guarantee regarding the number of connections or consumers which shall be allotted to a particular person. It is subject to variation. It could be unilaterally changed. It is on acceptance of this basic condition that the members of the Petitioner Federation were allotted the rights for distribution. Besides this, each distributor was allotted the area of operation. He had no right to go beyond it. However, during the period of 4 years, from 1994 to 1998, the selection boards were not functioning. Thus, despite demand, the new distributors were not selected and appointed. My lord, thereafter, my lord, I will rely on paragraph 30. It is true, initially ceiling limits had been fixed for different areas, but with release of 1 crore of more connections in year 2000, the limits have been busted in many cases. Such instances have been given by the respondents. In this situation, the government of India had taken the view that each distributorship should be made viable. It was in conformity with the terms of the appointment governing the dealers, not contrary thereto. Under the agreement, the area of operation and number of consumers could be varied. My lord will kindly mark the words, my lord, could be varied. The present action does not even violate the number as initially enrolled with the dealers. My lord, thereafter, I'm relying on paragraph 31. In view of the above, it is held that the instructions are not arbitrary, unjust, unfair. These do not violate any provisions of law. These are not contrary to the guarantee enshrined with Article 14 of the Constitution. My lord, thereafter, paragraph 34, if my lord kindly takes, as already noticed, no details regarding the expenses incurred or likely loss to be suffered by any of the member of the Petitioner Federation have been given. In the absence of the data, it is difficult to say that the petitioner would actually suffer any loss. My lord, this was the situation when there was not the 100% ceiling limit. My lord, but by this 2025 circular, the ceiling limit has been enhanced to 100% complete. 100% viability has been achieved in this particular circular. So there is no loss. Moreover, the distributors which are unable to perform in this competitive scenario, the government is helping those distributors for more customer penetrability, for more customers getting satisfied and getting quick refills. But otherwise, what is happening in the situation is that there are only few distributors who are controlling the entire market. Malad, it is a monopolistic situation which the government is trying to interfere with. Malad will kindly take thereafter the sentences. However, it appears to be reasonable to assume that in view of the closure of the extension counters, the number of consumers registered with the different distributors would be reduced. Since the distributors had been permitted to open extension counters, Malad will kindly see the last paragraph. In any case, the increase or decrease in the number of consumers allocated to a distributor was clearly governed by the terms of appointment. Malad, as I have demonstrated before, my lord.
You are reading in any.
My lord, I am reading that paragraph 34, last 4 sentence.
Yes.
In any case, the increase or decrease in the number of consumers allocated to a distributor was clearly governed by the terms of appointment. It was permissible. Just as the oil company could increase the number of consumers, it was also entitled to decrease it. It is in the background of this factual position that the applicability of the principles of natural justice has to be considered. The principles of natural justice cannot be subjected to legal straitjackets. These principles belong more to common consciousness of mankind than to judicial science. These are general principles of law common to civilized communities. Simply put, the rules of natural justice are no more than principles of fair play. These are meant to promote justice. My lord, this particular writ petition, thereafter, my lord, if kindly sees the last paragraph, my lord, in view of the paragraph 41, my lord. My lord, if kindly takes paragraph 40 also. In view of the above, it is held that members of the petitioner federation have been allotted distributorships for specific areas. The area is clearly defined. The area of the consumers of each dealer could be varied by the oil marketing company. Even the right to transfer consumers from one distributor to another has been duly reserved. Thus, the existing distributors were permitted to open. My lord will kindly takes, my lord, thereafter the last paragraphs, my lord. In view of the above, we find no merit in this writ petition. It is consequently dismissed. Interim order shall stand vacated. My lord, this particular writ petition, the Punjab and Haryana High Court had the occasion to deal with.
This matter pertains to the instruction of 2001.
My lord, this pertains to earlier. My lord, earlier also the oil marketing company. This is not in connection with this particular circular. But since my learned friend was relying on 2018 circular, earlier orders passed by the Honorable Court, Honorable High Court, my lord, that was pertaining to the earlier circular, not this circular. But my lord, the concept is similar, exactly similar.
The ground that you have again issued the similar circular.
Well, that is not similar. What I have submitted as 100% viability is there in the new circular, which is not policy decision, which is not there in the earlier policy decision. Well, this particular policy decision allows the existing distributors to achieve 100% viability after which, my lord, the transfer will have effect. My lord, this particular judgment which I am relying on is on the concept of customer transfer, which has also been submitted before my lord by the petitioners before today. My lord, this particular judgment had been carried to the Honorable Supreme Court, my lord. The Honorable Supreme Court has refused to entertain. My lord, I am placing, my lord, the order of the Honorable Supreme Court also.
No, that is in respect of earlier instructions.
My lord, the earlier circular.
Yes, earlier.
My lord, but that is also transfer. My lord, that is also transfer of customer base. My lord.
Thereafter, you have issued new circulars.
My lord, the oil marketing companies have issued a new circular allowing 100% viability. That was 75% as observed in the earlier order.
Whether on the basis of these instructions?
No, my lord.
Not that.
No, my lord.
Why you are relying these circulars?
My lord, I am attacking, my lord, today before my lord, in my respectful submission is that I am attacking the principle that as has been placed before my lord, that OMCs cannot transfer customer base from one distributor to another. But this concept has been upheld by various judicial pronouncements in India, by the Punjab and Haryana High Court, by Kerala High Court, which has been refused by the Supreme Court. My reliance is not because of this existing circular which has been impugned today before my lord in the writ petition. The Honorable Supreme Court in this particular order, my lord, has refused to entertain the special leave petition.
Yes.
Thereafter, my lord, I am relying on 2003 SEC Online Kerala 417. My lord, I am placing the judgment. But today, my lord, my endeavor before my lord today, since my lord, my stand, my lord, is to a certain extent in these writ petitions has been made out that since there are existing orders passed by the Calcutta High Court in an earlier circular, the oil marketing companies has been restrained from giving effect to the policy decision of 2018, as has been ventilated before, my lord, in the earlier orders. My lord, thereafter also there's another order which has been passed by the Bombay High Court Nagpur bench, as has been placed by my learned senior friend, my lord. But that, my lord, if my lord kindly sees, my lord, has not considered the decisions of the various high courts which has upheld the policy of customer transfer.
Okay.
Or in cases of 100% viability, it has not considered. My lord, my case today is that the distributors or existing distributors do not have any right over the customers. The customers are of the oil marketing companies. The distributors have entered into distributorship agreements with, my lord, the oil marketing company, wherein the right of the oil marketing company to increase, decrease, or appoint additional distributors or to transfer customers, as my lord, I have demonstrated through the LPG manual, my lord, has been reserved. Well, these agreements have been signed specifically by the distributors. My lord, I am now relying, my lord, on 2003 SEC Online Kerala 417, my lord. My lord will kindly seize, my lord. Kerala 417. My lord kindly takes paragraph 10 of the concerned judgment, my lord. Now, this is also division bench of the Kerala High Court.
Yes.
My lord, paragraph 10 says, admittedly, an agreement had been executed at the time of appointment of the petitioners as distributors. A perusal of the terms of the agreement shows that the corporation had specifically reserved the right to appoint one or more additional distributors in the same territory. This could be done without any reference to or consent of the distributor. Still further, it also provided that the distributor shall be liable to confine himself to effect the sales in the area or territory specified herein above, but the corporation shall be entitled, without the consent of the distributor, to enlarge, reduce, increase, or modify such area or territory to such other place as may from time to time be authorized by the corporation in writing. Thus, it is clear that under the agreement, the corporation was entitled to appoint additional distributors for the area which has been allotted initially to any dealer, including the present petitioners. Still further, the corporation was also entitled to unilaterally reduce the area which may be initially allotted to a dealer. Another fact which deserves mention is that in clause 11 of the agreement, the distributors had specifically undertaken to faithfully and diligently observe and carry out all direction, orders, and terms of the conditions as may be issued from time to time. Thereafter, paragraph 11. In view of the terms of the agreement, it manifests that distributors, like the petitioners, do not have any indefeasible right to effect sales within the area allotted to them. The area of the operation could be unilaterally reduced. New distributors could be appointed for the same area. This is precisely what has happened in the present set of cases. Thereafter, paragraph 12, Mr. Gopal Kumar Nair submits that the petitioners have no objection to the appointment of new distributors. However, the corporation is now trying to take away the customers registered with them. So far as this aspect of the matter is concerned, that Mr. Dominic has produced before us a photocopy of the letter dated March 23, 1989. This was letter of intent issued by the corporation to the petitioner number 1 in OP number 15097/2023. In this letter, it was specifically mentioned that the petitioner's area of operation will cover Quilon. This is, however, subject to change as may be considered necessary by the corporation at a later date, even after the distributorship is commissioned. Further, from time to time, you may be required to take over some existing customers also of other distributors in your area. Similarly, you may be required to surrender some customers to other distributors. Thereafter, paragraph 13, my lord, a perusal of the letters, particularly the portion as quoted above, clearly shows that the corporation had informed the prospective distributors at the threshold that the number of customers could be altered at any stage. Thus, it is not the petitioners are being taken by surprise. In fact, they had been warned about it even before the execution. Thereafter, paragraph 15, we are unable to accept the contention. Admittedly, the corporation has reserved the right to reduce the area of operation. It has also reserved the right to appoint additional distributors for the area initially allotted to them. The reduction in the area of operation would automatically result in the number of customers registered with the dealer. Equally, the appointment of new dealers for the area carved out by the operational limits of the existing dealer would automatically result in the reduction in the number of customers. Thus, it cannot be said that the action of the corporation or the government of India violates the terms of the agreement. My lord, thereafter, this entire writ petitions, my lord, if my lord kindly sees, has, my lord, the prayers of the writ petitioners has not been allowed, my lord. Thus, the OPs, my lord, paragraph 28, as the OPs 373638 are dismissed. My lord, this particular judge, from this particular judgment, my lord, an SLP was preferred before the Honorable Supreme Court, my lord. The Honorable Supreme Court, my lord, in my respectful submission, had not entertained that particular special leave petition. My lord.
Yes.
My lord, thereafter, my lord, I am relying once again.
So is there any document in this case regarding the letter?
My lord, which letter, my
reducing
lord?
Customers like that?
Well, the LPG manual, my lord, the division bench judgment has observed the LPG manual, my lord, has been signed by the customers or other distributors, my lord. So the distributors are bound by the terms and conditions of the manual, existing transfer, reducing, enlarging, transfer of customer base, surrender of customer base.
No, I want to know whether
Yes.
there is any letter like that in this judgment, in the Kerala judgment.
My
on
lord,
the LPG Union of India. The Honorable Division Bench has referred about a letter.
my lord, letter of the oil marketing company, my lord, which, yes.
Letter
My lord,
of
that
oil-
particular letter, my lord, today I'm not carrying with that particular letter. My lord, if my lord desires, my lord, I'll place before my lord the particular letter, my lord, which is in connection with the policy decision previously also regarding transfer of customer base.
In the division bench, in the cases there is a letter at the time of appointment, at the time of execution of the agreement.
My lord, that is the agreement, my lord. That is the agreement which, my lord, I have relied on, my lord. These distributorship agreements and this LPG manual, these are the same agreements.
There are separate agreement or the same agreement?
My lord, my lord, I'll take instruction, but these are same agreements, my lord. These are all agreements of the entire India, my lord, standard agreement formats.
Read paragraph 12.
Yes, my lord.
It is said about a letter.
My lord, paragraph 12, my letter of intent, my lord, I think. My lord, in this letter, my lord, this is a letter of intent. My lord, this letter of intent terms are similar to the agreement, my lord, which has been executed throughout India by the all OMCs.
So where is the clause in the letter itself or agreement itself? Corporation
My lord, the
has
agreement which
prospective-
my lord I had relied. My lord, this agreement, my lord, I have relied today before my lord, the distributorship agreement. My lord, clause 12, which my lord I have relied, my lord, page 42, my lord. In the writ petition, my lord, LPG manual and my lord, the agreements are part of the entire agreements which are executed by the distributors and the oil marketing company. My lord, kindly take page 42 of the writ petition. My lord,
Where is
page
the
42.
clause that the corporation has authority to direct to surrender any customer.
My lord, that my lord, I have shown my lord in the dealership agreement,
Where is
page
the-
42, my lord. My lord, LPG manual, HP gas manual, my lord, kindly takes clause 12, my lord. It's my duty, my lord, to clarify before my lord today a stand which which rather the OMCs. Yes, my lord. The dealer shall faithfully and diligently observe and carry out directions, orders, terms, conditions as may be issued by the corporation from time to time and may be contained in the gas manual and any amendments or modifications as may be made by the corporation thereto from time to time.
No,
The dealer hereby confirms. Yes,
that
my
is
lord.
all very general and omnibus.
My lord, but the LPG manual which my lord I have placed before, there has been a connection, there has been a surrender, my lord. There's a terminology, my lord, surrender of dealerships.
Perhaps there are other clauses in that agreement, I think,
My lord, which agreement, my lord?
which referred before the Honorable Division Bench of Kerala High Court. Paragraph 12 is very clear.
Yes, my lord.
The agreement which was impugned before the Honorable Kerala High Court specifically dealt with the clause that the corporation has reserved right to give direction to surrender the customers.
Yes, my lord.
What is the right? What is the clause?
Well, that is the LPG manual, my lord. With deepest respect, my lord, that is the LPG manual throughout India, which is operating along with the dealership agreements, my lord. My lord, there is specifically that clause which I have relied today before, my lord. That all the distributors have entered into that sort of a clause, which is generally the general format for all the oil marketing companies. My lord, thereafter, the general unified guidelines also reserves these clauses, my lord. That they have to that the distributors have to surrender customers also.
Okay. Proceed. Yes.
My lord, 2021, if my lord is having, my lord, I've just passed.
2003 SCC.
My lord, 2021, my lord, I'm relying. I'm just. No, where? No, my lord, I'm just placing before my lord once. If my lord kindly takes 2021 SCC online Kerala Irankulam Division Bench Judgment 4833. My lord kindly takes. 2021 SCC online Kerala 4833.
Yes.
My lord, these are also on the same concepts, my lord, as my lord I have placed. My lord, I will from in this particular judgment, my lord, I am placing paragraph 8. My lord, kindly sees, my lord, first paragraph of the judgment, my lord. A distributor of domestic LPG is before this court asserting his right to retain the consumers who have been subscribed with him, The learned single judge found that the transfer of consumers from one appellant to the newly appointed distributor does not affect the appellant's business, since he would continue to have average refill sales corresponding to the ceiling limits of the market. My lord, this is the same concept which is in the present writ petition. My lord, 2021 SCC online 4833 paragraph 8 thereafter, my lord, I am humbly praying before my lord, if my lord kindly sees.
Yes, proceed.
Yes, my lord. My lord, paragraph 8. Reduction of area or territory through geographical would necessarily involve transfer of consumers, since no territory can be assigned without reference to the consumers therein, and there can be no consumer in isolation without reference to the territory or area. A consumer subscription is based on and presupposes the location where the product is to be delivered, and he cannot have an existence divorced from the area or territory within which he uses the LPG cylinder. An existing distributor may cater to a number of consumers in an area, and with the increasing subscription, it may not be possible for the distributor alone to cater to the needs of all the consumers in the area. The profit element or business efficacy is not the sole consideration in public utility service, and the consumer's interest has primacy. It is in this context there are appointments made of new distributors to cater to the increasing number of subscribers, which is a natural consequence of the area or territory of a distributor being reduced or modified for new appointment. The consumers, new or old, who have their location in the area or territory which stands severed from the existing distributor would necessarily have to be transferred to new distributors on which the existing distributor can have no grievance. My lord, thereafter paragraph 9, my lord, we cannot accede to the argument of Sri Vijayanand that since the contract entered into between the distributor and the oil company is a commercial contract, the business efficacy of the distributor has to be given primacy. We cannot but observe that the argument raised as to whether the consumer belongs to the company or the distributor completely ignores and compromises the interest of the consumer. That too, the consumer of a public utility service, which is brought under the Essential Commodities Act. We reject the contention raised by the existing distributors of business efficacy of the distributors being reigning factor. They expect an increase in turn over the years, based on which expectation they had taken loans for vehicles, infrastructure, and so on, as pleaded in the writ petition. If prudence dictates to them that business is not viable, it is always open to them to stop it. Service, prompt and effective. In this case, the regular supply of LPG cylinders is what the state and its instrumentalities strive to achieve when dealing with public utility services. If the corporation feels the service will not be effective for a reason of increasing subscribers as per norms laid down by them, they are entitled to appoint new distributors to cater to the multiplying subscribers in a given area by bifurcating the already allotted area between the existing and the newly appointed distributors. We cannot accede to the plea of the distributors that it is in their business efficacy which should rule the roost than the interest of the consumers. Such high-handed attitude of the distributors ignoring the interest of consumers, especially in a public utility service, cannot be accepted. And as rightly pointed out, it results to monopoly and the consumer would be left to the vagaries of individual distributors. Thereafter, paragraph 10, the liquefied petroleum gas regulation supply distribution order 2000 was specifically referred by S. Nirmalam. The distributor as defined under the LPG order is a person, firm who has been appointed by the government, oil company, and engaged in the business of purchase, sale or storage of sale of LPG cylinders to the consumers on the basis of an agreement with the government oil company. Hence, the agreement entered into between the distributor and the company has a statutory backing. The clauses of the agreement also support the case of the respondent company. Clause B1 reserves the right of the corporation to appoint one or more additional distributors in the same territory referred to in clause 1A, which is the territory assigned to a distributor in that agreement. The distributor cannot object to such an appointment, and subclause 3 further entitles the corporation at its discretion to reduce, restrict, modify, alter the area of distributorship territory, which decision is binding and final on the distributor, while subclause 4 prohibits the distributor from selling outside the territory. Subclause 5 exhorts the distributor to enroll as many consumers and canvas business for developing the increasing sales of LPG. As far as the appellant is concerned, the agreement is one entered into and then continued for the years. Thereafter, paragraph 11, the LPG manual, which I had relied on today, issued by the consortium of oil marketing companies at chapter 2 deals with marketing. Clause 4.7 deals with the relationship between the consumer, distributor, and OMCs. The distributor is appointed by the OMCs on principal-to-principal basis. Distributor is responsible for all business dealings with the OMC consumers. The consumer is enrolled by the distributor on behalf of the OMC. Thereafter, paragraph 12, we also extract one sentence of clause 5.1 dealing with the subscriber. This is different. Thereafter, we now come to enter into distribution. Thereafter, kindly seize paragraph 14. We now come to the argument of the contract being between principal and principal, which arises from clause 17. In all contracts or engagements entered into by the distributor with the consumers for sale of LPG, the sale, installation, repairs, appliances, and or connections thereof with LPG cylinders equipment, the distributor shall act and shall always be deemed to have acted as a principal and not as an agent on account of the corporation. Well, the corporation shall in no way responsible. It's a different thing. Paragraph 15, last sentences. There cannot be any proprietary rights of the consumers on the company, especially in a public utility system, and it is the option of the consumers to choose the company or the distributor subject to only those existing in the area of operation. Primacy of the consumers cannot be given a go-by, and there cannot be any proprietary right on the company, and least of all on the distributor of the consumers canvassed by them and serviced. The consumer has the freedom to migrate from one distributor to another. Thereafter, paragraph 16, the division bench of this court in All India LPG Distributors Federation, Supra, held in, we are unable to accept the contention. Admittedly, the corporation has reserved the right to reduce the area of operation. It has also reserved the right to appoint additional distributors for the area initially allotted to them. The reduction in the area of operation would automatically result in the number of consumers registered with the dealer. Equally, appointment of new dealers for the area carved out with operational limits of an existing dealer would automatically result in reduction of the number of consumers. Thus, it cannot be said that the action of the corporation or the government of India violates the terms of the agreement. Having considered, we reject the instant appeal. Paragraph 18.
Yes.
Now to that kind. My lord, I am relying further on a division bench judgment of Kerala High Court, Ernakulam. My lord, is a 2022 SCC online 4599. My lord, this has considered also the 2018 situations. This is a 2022, my lord. 4599. My lord, paragraph 1 says the caption writ petitions are public interest litigations filed in respect of transfer of LPG connections from one distributor agency to another without informing the consumers, customers, and challenging the orders thereto, and also a rival direction in respect of the implementation of the orders issued and transfer of LPG connections to the nearest distributor of the consumers at the earliest. Fundamental issues raised in the writ petitions and the documents relied upon being a typical narration of the facts separately not required, my lord. My lord, thereafter, my lord, I take my lord to paragraph 27. To put it short, the sole question to be considered is whether there is an illegality or arbitrariness in transferring a consumer from one distributor to another appointed by the oil marketing companies, corporations. In our considered opinion, the guidelines and the agreement executed by and between the oil marketing corporations and the distributors would show that the consumers are under the direct supervision and control of the oil marketing corporations. And the consumer cannot turn around and say that they are entitled to continue with the existing distributors or customers. The conditions contained under the guidelines would make it clear that the entire procedure for appointment of distributors and the supplies to be made to the consumers are all streamlined and structured in a very emphatic and disciplined manner so as to avoid complex situations in the business dealings by and between the parties. Thereafter, paragraph 28, the guidelines and policies are introduced by the government of India and oil marketing companies to render better services to the consumers of LPG connections, taking into account the distance between the consumer and the distributor, the feasibility and viability of the supply, efficient services, and cost-effective methods in order to protect the interests of the consumers. When the distribution of the LPG cylinders is regulated and controlled under the Essential Commodities Act of 1955, the oil marketing corporations are controlling the appointment of the distributors and supply of LPG cylinders. It is for the oil marketing corporations to take into account the necessary and required viable aspects for effectively and safely supplying gas cylinders and rendering services to the consumers. My lord, thereafter, paragraph 29, my lord. Moreover, no right is vested with the consumers in objecting to the porting done by the oil marketing companies, corporations, government of India under the guidelines issued in respect to the LPG portability. The object of the company portability guidelines discussed above granting liberty to the consumers to protect the interest of the consumer by consumer themselves, which means if a consumer wants to migrate, this is a situation where the consumer wants to migrate, they are entitled to do so, and that will not stand in the way of the oil marketing companies, corporations implementing guidelines and orders issued by the government. Thereafter, paragraph 31, if I may kindly please. After due deliberation of the facts and law as discussed above, we are of the considered opinion that there is no illegality or arbitrariness or other legal infirmities in the action of the government of India and the oil marketing companies porting the consumers from one distributor to another. In our view, such a course of action adopted by the government and the oil marketing corporations would apply only inure to the benefit of the consumers, and by no stretch of imagination it can be visualized and presume that the shifting of consumers from one distributor to another would in any way prejudice the consumers. Thereafter, this writ petition has been accordingly disallowed. This is a public interest litigation before the division bench of the Kerala High Court. Actor. না আমি আরে আমি একটা ফর্মিডেবল অপোজিশন ডিল করতে গিয়ে তো শুয়ে পড়ছি পুরো।
Yes.
My lord, I am relying, my lord, on an Andhra Pradesh High Court, my lord, order passed by the Amravati bench. My lord, in this particular matter, my lord will kindly take this particular judgment. My lord, this is a server copy of the Andhra Pradesh High Court Amravati bench. If my lord, this is the India Kanun version, my lord will kindly see of this particular judgment. এটা সাইটেশন না তোমাকে আমি দিয়ে দিচ্ছি তোমাকে আমি দিয়ে দিচ্ছি না, আমার কাছে আছে আমি জাস্ট চেকিং আউট তোমার ওখানে আছে দেখো ঠিক আছে মানে will kindly take yes my lord will kindly takes this my lord the decision my lord unreported decision my lord this particular my lord common order the learned counsel for respondents stated contemplating a situation
Yes.
my lord in this particular matter my lord the petitioners in these writ petitions are LPG distributors my lord paragraph 7 my lord I am relying on. The petitioners in these writ petitions are LPG distributors of Indian Oil Corporation. The petitioners challenge the communication circular of the Indian Oil Corporation transferring the existing connections to another distributor appointed by the corporation as illegal and arbitrary. The petitioners also contend the corporation does not have the authority or right to reduce existing connections with the distributors. During hearing, Sri C. Raghu, learned senior counsel for the petitioners, would contend that the distributorship dealership agreements that were entered in favor of the petitioners, under which the petitioners were granted dealerships, do not prescribe any maximum number of cylinders connections that can be held. By issuing the impugned circular, the petitioners were infringed from their right to expand their business by registering new connections and enrolling new consumers, which has resulted on account of the periodic increase in the ceiling limits, targets by the respondents in respect of existing customers. It is contended that the impugned circular, there's a circular, confers new benefit to the new distributors and is contrary to the doctrine of legitimate expectations, promissory estoppels, and violative of the Article 19(1)(g) of the Constitution. This deals with the 2018 circular. Thereafter, paragraph 19, Learned Senior Counsel contends that circular number SL1601 dated 4/1/2018, contemplating transfer of customers from one distributor to others, is being applied to old distributors also. The old distributors would be operating in the respective notified areas. Since they are unable to reach 50% mark, the distributors whose customer base is over and above 75% would be transferred to them. Here in the fact, in this particular circular, which is impugned before my lord, 100%. Therefore, the contest of the respondents that the transfers would be basing on the area wise is incorrect, since the same circular is being applied to the existing old distributors also, who are doing less than 50% business. Learned Senior Counsel submits that raising all the above grounds, the dealers within the state of Maharashtra filed WP challenging the circular. The division bench of Bombay High Court had set aside the policy in circular 2018. Learned Senior Counsel, thereafter paragraph 11, Learned Senior Counsel contends that once the circular has been quashed by Bombay High Court, it does not exist at all, and it is effaced from the records of the respondent. Once a writ petition is entertained before a particular High Court, since the part of cause of action arose to the distributors therein, in that state under Article 226(2) of the Constitution of India, when such High Court sets aside the circular, which is applicable throughout India, the same is effaced from the records, and the respondents cannot contend that the circular would not be implemented within the jurisdiction of Maharashtra, since the same has been set aside by Bombay High Court, but would be made applicable to the other part of India. Thereafter, Learned Senior Counsel contends the Honorable Court being within the ambit of the definition of the state, and that Bombay High Court had quashed the circular, still the respondents would implement the said circular in the state. Learned Senior Counsel contends that once circular has been set aside, it does not exist, therefore it cannot be implemented. In support of his contention, Learned thereafter judgments were placed. Paragraph 13, paragraph 14 also Learned Senior Counsel appearing for the paragraph 14, it says that the Learned Senior Counsel appearing for respondents 2 and 3 submits that the corporation is entitled at its sole discretion to reduce, restrict, modify, or alter the area of distributorship or territory in the terms of the agreement. The corporation takes decisions keeping in view the needs of the effective supply of cylinders and commercial viability of new distributorships from time to time. The writ petition seeking enforcement of right or obligation on distributorship agreement is not maintainable. It is contended that the High Court exercises jurisdiction only over states over which it is the High Court. It has no jurisdiction over the rest of the country. Once the matter has been decided by one High Court, the other High Courts may or may not take a different view, since it virtually usurps the jurisdiction of other High Courts in the country whose jurisdiction is limited. Learned Senior Counsel would submit the decision taken by the gas companies for enlistment of additional dealers for distributorship of LPG gas in the area where dealerships was already allotted to some other members of the unofficial respondents is only in the interest of the public and to cater to the minimum needs of the consumers within the vicinity. Therefore, the decision is only in public interest, and consequently, the courts should be restrained to interfere with any such policy decisions. In support of his contention, Learned Senior Counsel placed reliance on judgments of the Honorable Supreme Court in Union of India versus R. Thiagarajan. There are certain judgments which has been referred to in this matter, I am taking thereafter to paragraph 20, discussion. The corporation has been consistently awarding LPG liquefied gas dealerships to the individuals who fulfill the requirements set forth in the tender conditions. Once these dealerships were granted, they have remained operational for several decades. Over time, however, urban areas have experienced rapid expansion, leading to increased population densities and changes in the demand for LPG connections. As urbanization progresses and global reliance on LPG grows, the original number of dealerships established at a particular point in time may no longer suffice to meet the evolving needs of these expanding urban areas. The Union of India, along with state governments, is actively advocating for safer and more environmental friendly cooking. Malad, this is different. Malad, thereafter, Malad, I am taking Malad, this paragraph, Malad, leaving. Malad, paragraph 21, Malad speaks of, in the middle portion, if Malad kindly sees, to address these needs, effectively a circular dated 14/1/2018 was issued. Has Malad seen Malad? Paragraph 21 at page 11.
21.
Malad, in the middle portion, Malad kindly sees, Malad?
Yes.
To address these needs, effectively a circular dated 4/1/2018 was issued. Therefore, this circular was necessitated out through research and market analysis. The respondent corporations must reassess and standardize their approach to LPG distribution. The goal is to ensure a uniform implementation of the scheme that meets the requirements and expectations of all stakeholders, thus improving the efficiency and effectiveness of the distribution system for the benefit of public. The process of customer transfer for distributorships awarded under the selection guidelines prior to the unified selection 2016 are as follows. This was something separate. Thereafter, paragraph 22, upon reviewing the circular, it is in its entirety, it becomes clear that its recommendations are aimed at aligning with public expectations and enhancing convenience for a broad audience. To address these objectives and to serve a public interest more effectively, all corporations collectively established and implemented a set of unified selection guidelines on 14/11/2018. These guidelines were designed to streamline the process of ensuring consistency across the board, thereby improving overall service delivery and meeting the evolving needs of the community. The process of customer transfer for distributorships awarded under the Unified Selection Guidelines of 2016, that has been elaborated. Thereafter, paragraph 23, it further observed that in pursuance of the Unified Selection Guidelines, respondent corporations granted LPG dealership in favor of selected individual firms, companies. In the said process, the present impugned circular was issued by the respondent corporations to meet efficiency and performance of dealership network in urban, semi-urban, rural areas. Thereafter, the entire judgment, deals with the requirement, of transfer. Paragraph 25. Accordingly, to the policy, there has been an expansion in the distribution network within metropolitan areas. As a result of this expansion, the petitioner herein were awarded new dealership opportunities, which included imposing caps or maximum limits on the existing dealerships. Given that the petitioners have benefited from this ongoing policy, they cannot now argue that the creation of new infrastructure, despite their significant investment in developing facilities, has led to issues with existing customers of particular dealers. Specifically, they cannot claim that existing dealers have faced problems related to customer inconvenience, safety, or unmet needs. In the absence of fair basis, issuing the challenge circular, the reallocating more 25% consumer connections from a specific dealer effectively redistributes the dealer connections to others, disadvantaging the current dealerships. The action is deemed untenable, unreasonable, and contrary to the audit policy and contrary to the public good, given over 90% of the LPG distributorship network is controlled by few public sector companies such as HPCL, BPCL, and IOCL. These companies dominate the LPG distribution in metropolitan areas. Thereafter, it cites the reason behind, if the corporation decides to, will kindly seize the last sentence in that paragraph. If the corporation decides to establish another LPG distribution network due to performance and efficiency issues, the large number of connections and need to be public demand justify the same. Consequently, the argument of the learned counsel for the petitioners that their significant investment in infrastructure should be a crucial factor does not hold in the light of the overarching considerations as mentioned above. Sees paragraph 26, It is important to note that the petitioners became LPG distributors for respective corporations under the similar policy, which involved setting maximum limits or ceiling of refills for existing distributors. As a result, the petitioners cannot claim the right to prevent the respondent corporations from enforcing the current circular simply because it reallocates their connections and causes them financial strain. The petitioner's argument that they have invested significant amounts in infrastructure does not justify restraining the corporations from implementing the policy.
This judgment is in respect of the
2018. The earlier circular.
Earlier circular. So what you want to submit?
I want to submit this particular writ petition. Thereafter, in paragraph 34 at page 22.
No, this court and the division bench has already taken view on that matter. So why you
My lord,
agitating?
My lord, I am reiterating to my lord, these particular judicial pronouncements were not placed before the honorable court during the round of the decisions which has been rendered. Neither the honorable Supreme Court's decision regarding the refusal of Supreme Court to entertain the SLPs from these orders had been entertained. My lord, this particular matters or these particular pronouncements had not been placed before the honorable court.
No, I understand. But this court and the division bench has already taken a view in respect of the earlier 2018 notifications.
My lord, 2018, yes.
Circulars.
Yes, my lord.
And the bench of this is
My lord, but that is 2018, my lord. My lord, yes, my lord, my lord,
Single bench order.
my lord, this is definitely a single bench order, my lord.
Order?
My lord, but I have placed division bench orders before my lord today also regarding the earlier circular of 2018. My lord, these were not placed before the honorable court, my lord, at that point of time. My endeavor, my lord, today, definitely, my lord, there is an order pronounced by the honorable division bench of this honorable court,
Yes.
and also my lord,
yes.
and my lord on the by honorable Justice Chaudhuri, my lord, wherein my lord the 75% limit was there. But this circular, my lord, is different from that circular on the aspect that
No, that I understand your submission. But why you are again?
no, I am
Something
just basing,
this-
my lord, I am harping on this decision simply to my lord demonstrate before my lord that
There are
if
several.
yes, my lord, if my lord the persuasive consideration of a judgment is taken by one of the honorable high courts, then definitely there are other judgments also which definitely upholds this circular or the
Whatever
policy.
maybe the honorable Supreme Court has not taken any decision on that point.
My lord, honorable Supreme Court on this particular circular has not taken this.
Not taken any decision. So till the decision be taken, the division bench is clear view that the view taken by the honorable High Court and the Bombay High Court.
My lord, but this particular circular has been challenged before the Nagpur bench of the Bombay High Court.
Yes.
My lord, Nagpur bench of Bombay High Court has not considered these particular situations or judgments which has been placed before my lord today. But it is only a single page order which the oil marketing companies are definitely going for appeal, my lord, from that particular judgment. My lord, it doesn't take, it only takes, my lord, a judgment of the Bombay High Court only, and in a one-liner, it comes up with a conclusion that we cannot go into it. But my lord, these particular judgments were not placed before the honorable court at the point of time when this particular 2018 circular was under challenge. Neither the honorable decisions of the honorable division bench of the various courts and also the refusal of Supreme Court to entertain on those grounds has been taken into consideration. And my endeavor today is that, my lord, to apprise before my lord the situation that other high courts or other high courts, division benches of other high courts have allowed the circular to work.
Okay. No, let him finish. Yes, anything?
My lord, furthermore, my lord, I have completed, my lord, I have placed all the judgments, my lord.
So what is the status now?
My lord, status has now, as my lord, senior friend, my lord, has placed for my lord that they are allowing.
All the
My
customers.
lord, all, my lord, not, they are allowing 100% viability of the existing distributors. Thereafter, after the 100% achievement, they are allowing the customers to transfer to those who are.
I want to know what is the status in respect of the impugned notice, impugned letters issued by you.
160 and 161.
160 and 161.
My lord is inquiring whether the oil marketing companies is giving effect to this particular.
Yes.
These circulars or not. My lord, as I have taken instructions also from this particular emails which is appearing, my lord, they are allowing the customers definitely in the particular in pursuance to this particular policy of 2025 to get shifted, my lord. But if my lord, that I am leaving it to my lord today before, because the email speaks of the fact that there's a customer shifting going on.
Okay.
By all the oil companies, not only my lord, by the Hindustan Petroleum Corporation Limited.
Very good.
With deepest respect and humility, my lord, I am respectfully submitting, my lord, if my lord kindly considers these judicial pronouncements before my lord comes to a conclusion, my lord, that this policy guideline should not be interfered with.
Very good. Yes, reply.
Your submission and reference on behalf of the oil company. As I understood, the prayer of the respondent is that your lordship will declare the true judgment of the division bench part inferior and shall take a different figure. Possibly, my lord, another law, this is not possible. Sitting in a single bench, my lord, possibly division bench judgment cannot be interfered with, while the issue are same. Not a single judgment has been relied on. in respect of the present circular 22nd May 2025. One single event judgment of 2018 circular has been placed. So for the Bombay High Court is concerned, that has been dealt with by a division bench. Just one paragraph of 3 judgment I shall rely upon before your lordship. Another contention is that sitting besides him, I have heard my lord at least 50 times he has argued area of operation. That is his main argument. Kindly turn to my lord the division bench judgment of the Bombay High Court at page 67. How this thing has been dealt with by the division bench. Page 67 it starts. Your lordship, kindly turn to page 90. Right. 90 paragraph 15. This specific clause which has been placed before lordship that has been elaborately dealt with. That area of operation curtailment does not mean curtailment of customers. Kindly read my lord paragraph 15. Relying on the distributorship agreement, Mr. Sanchiti thereafter argued the PPCL is entitled to enlarge, reduce, or modify the territory of its distributorship. The petitioners are therefore also entitled to reduce the number of customers. In order to deal with this submission, it would be necessary to produce this clause has been placed with your lordship just now. And that has been quoted in paragraph page 91. Now your lordship kindly turn to paragraph 16. At page 91, may I read my?
Yes.
In our page 91. In our opinion, the aforesaid clause is restricted to area or territory and not customers, as is being sought to be contended by Mr. Sanchan. We do not believe that a corollary of PPCL's right to reduce the area of territory would also include a right to reduce the existing customers. Contrary to the submission, it appears that the distributorship agreement contemplates instance of causing the petitioners to increase their customers and not decrease their sales. Illustratively, clause to answer that has been quoted, my lord. They kindly turn to my lord. Page 93. The aforesaid proposed clause so and so being also Dhorn's argument that the impugned circular is contrary to the doctrine of legitimate expectation and promissory estoppel and therefore violate of so. In order to understand the extent of petitioner's explanation, we have perused the various arguments according to Mr. Dhorn. A perusal of this communication would reveal that so and so. Then kindly turn the page, my lord. Other points have been dealt with, and your lordship has also dealt with this provision. If your lordship kindly turn your lordship's order 134. So far the area of territory is concerned. 134. Now it starts from page 134. You will have to kindly turn to page 142. 139, sorry. 139, paragraph 16, last 4 lines I'm reading, paragraph 16. A sentence starts in deciding, have you also got my lord? In deciding reasonableness of the circular appropriate to the dealership agreement, it is required to set out some relevant provision of the dealership agreement, clause 3 of the letter of so-and-so, corporation in favor of so-and-so. Trading area has been disclosed. Then, to justify the trading area in consonance with the dealership agreement, necessary clauses of the dealership agreement appears in clause 2.5b, which has been placed before your lordship, that has been quoted by your lordship. Then, it is argument on behalf of the learned counsel for the respondent number 2 that they have allegedly communicated in terms of agreement. It is further argument of the respondent number 2 that corporation has domain under entitled to, without the consent of the dealer, increase or modify the business area. Learned counsel for the petitioner submits that so and so. Kindly turn to page 141, paragraph 21. I am also in consonance with the observation of the Honorable Division of this court is of the law of the land should maintain a parity in so and so, modify the order so and so. Your lordship has also dealt with this. And the division bench of our High Court also considered the same. If your lordship kindly take up the order passed by the division bench at page, my lord, 144, 2 paragraph I shall read, my lord. Paragraph 6 and 7 at page 145. Area of operation. Paragraph 6 I am reading at page 145. In the said decision of the Bombay High Court, certain clauses of the agreement of distributorship entirely are conferring a right of the oil company to change the area of operation of the distributor has also come to be considered. The said consideration was effective in addition to the questioning the legality of the equivalent circular dated 9 July 2018 issued by the HPCL. Interpreting the said clause to restrict the power of the oil company to curtail and or alter the area of operation, the Bombay High Court held that the oil company could not, under the guise of the aforesaid provision, transfer any customers. This is a division bench. Today, my learned friend is seeking before your lordship, contract with this observation and order be passed. And what is the impugn order? Kindly turn my lord page 160 and 161. Is there any whisper about the curtailment of area? Straight away, I am taking these customers. Is there any whisper at page 160? Kindly read, my lord. First line. We wish to inform you, page 160. This is the first one. 1156 number of customers have been taken away. First line, we wish to inform you that 1156 numbers of customers have been transferred. Transfer has been given effect to then intimation from your agent so and so, gas market so and so, restriction of so and so, so and so. Is there any whisper about area of operation? Whatever judgment has been placed before lordship, all dealt with my lord areas of operation. None of the judgment dealt with my lord 2018 circular or 2025 circular. 2018 circular, only one single bench judgment has been placed. I am relying on two division bench judgment. Page 161, kindly see same verbatim. We wish to inform you that so number of customers. Wherefrom we shall get that these customers are of the area which I have not been allotted to do my business. But so far this part is concerned. Nagpur page judgment your lordship kindly take out 165. It starts from page 165. Kindly turn to page 4, paragraph 4 at page 166. That point has also been dealt with in the latest judgment while dealing with the present circular, paragraph 4 at page 166. It is contended that during the pendency of the aforesaid challenge, the oil companies have come up with a new policy dated 21st February 2025, which is identical in nature to the earlier policy so and so, except for a difference in the quantum of the ceiling limit. The learned division bench of so and so other column so and so has already issued notice and granted stay to the effect and operation so and so. So there is no difference. So far the 2018 circular is concerned, which has been quashed and set aside. My learned friend whoever is arguing, he has to argue the same before the Honorable Supreme Court to save the judgment of the, to distinguish the judgment of the Bombay High Court division bench. While a particular issue has been dealt with by division bench, whether a single bench can nullify the same. None of the judgment dealt with or placed before lordship considered 21st May 2025 circular. Only one judgment of 2018, which is a single bench judgment, I have placed before lordship Bombay High Court division bench judgment. Today it is binding effect of possibly my lord before lordship to pass an order in consonance with the orders passed by two division bench, considering my lord 21st May 2025 judgment circular. But so far the customer's benefit has also been argued. Today's situation is entirely different. The old judgments have been placed before lordship. Today, if I give a message, the cylinder will come to my home. Need not go to the dealership or distributorship officially. A message, a ring, phone call suffice the entire need. The old judgment which has been placed before lordship, almost single bench judgments, when there is a requirement, personally you have to go to the office room and give a call that these are my numbers, please send the cylinders. And that has also been dealt with by the division bench of the Bombay High Court in the previous matter. Your lordship was already gone through. And so far the manual is concerned, well, nothing I have found in my agreement that I have to follow the manual. In every document they have says I am button and binding by the agreement and the license. There is no provision, no whisper in the agreement that you are buying by this manual also.
Well, that my lord has shown, my lord. Manual is important. I'm sorry to interject, my lord. Senior friend, my lord.
Okay.
So my lord, so far manual is concerned, every time my lord manual is being changed. Other companies' manual is different also. And in my agreement, it has categorically been stated that you have to run the business following the terms and conditions of the agreement. There is no whisper about any manual. And so far, my lord, the judgment delivered by your lordship, which has been challenged before the division bench and also before the review court, that has been acted upon. They have already returned back all the customers to me. They have not gone to the Supreme Court, my lord. Whatever argument is my friend saying, this is also on behalf of the HPCL. They have acted upon in terms of your lordship judgment that has already been given to me. So they have not gone to the Supreme Court. So today, whatever submission in advance, possibly that should have been advanced by filing a SLP challenging the previous order. Well, these are my submissions. Then today, my lord, the status of the customers is that has been uploaded in the Portal. But that has not been given unless a client, a customer takes its cylinder from the new one. That cannot be given effect. It is only in the portal. We can say paperwork. These customers are also with me till today because they have not called for any cylinder from other office. Today that is also in the portal, only in the portal.
Okay.
That's my submission. You also kindly see the prior portion of my writ petition. Lordship need not go through the entire pair. Mandamas I have short for then G, kindly see pair G, H and I also. And returning back the entire customer, that is there also mandamas. So customers has physically has not yet been transferred. It is only in the portal. The moment they will ask for a cylinder, that will be given effect. That has not yet been done. This is my submission.
Yes,
Okay, it's fine.
yes.
How many just take 5 to 6 minutes, madam? Because what has already been said, and I do not wish to duplicate. My lord, I adopt, my lord, my learned senior friend's submissions. So, my lord, in my matter, my lord, your lordship, instead of recording my learned senior friend's name, my lord can record my name as making such submissions. So far as my petition is concerned, my lord, BPCL is the concerned oil company.
Your item number?
14, my lord.
Now, in item number 14, I am appearing for BPCL.
Okay.
That my affidavit of service may be taken on record. The issue is the same, my lord. In what your lordship has heard, my lord, it's the same circular which is under challenge. The circular of 21st February 2025. The only thing different, my lord, is the oil company out here.
Yes.
My lord, apropos what has fallen from HPCL and HPCL's learned lawyer, the issue in these writ petitions is not about territory or curtailment of territory. The issue is also, my lord, not about portability, whether one customer can move from one distributor to another. The issue is not about also new distributors coming in. New distributors can, of course, come in. My territory can be reduced. My customers can go to another distributor. That is not the issue. Today, the issue before your lordship is whether my customers can be taken away from me on the basis of an arbitrary and irrational circular. Earlier, as your lordship has seen, and your lordship has had the occasion to deal with it also, so far as the 2018 circular is concerned, that has been categorically been held to be arbitrary, irrational. Arguments of promissory estoppel, legitimate expectation have all brought in and been dealt with the learned Bombay High Court. And when the matter is pending before the Supreme Court, stay was sought, but no stay has been granted. So today, that is the law of the land, that circular does not stand. And today's circular, 2025 circular, is essentially the same. It's more or less a mirror image. The only difference is in the earlier circular, the ceiling limit was set at 15,000. Now the ceiling limit has been set to 25,000. Earlier, it was said that 20,000. Earlier, it was said, my lord, so far as the viability is concerned, it would have to be 75% viability. Now it is to be 50% viability. So the pith and substance of both the circulars is essentially the same. And that is exactly what we are challenging in this writ petition also. This determination of the ceiling limit to be 20,000 is completely arbitrary. This decision of the oil companies to forcibly take away my customers is also arbitrary and irrational. And I rely on the principles of legitimate expectation and promissory estoppel as well. And of course, my vested rights also, which have come in pursuant to my agreement with the oil company. My lord, all the other arguments are similar, my lord. My learned friend, my lord, for the other petitioners, my lord, has relied on certain orders passed by the Bombay High Court of the Aurangabad bench, where this particular order has been, circular has been stated. My lord, there are several other high courts also, Cuttack, Andhra Pradesh, and Kerala, which have also stated the same circular. May I just bring those orders to your lordship's notice? My lord, the first one, my lord, is an order of the Cuttack High Court, my lord, the Orissa High Court at Cuttack. The order is of 3rd July 2025. It's a short order, my lord. I'll quickly place the same. from paragraph 3 onwards. The grievance of the petitioners in the present writ petition is that the petitioners, who are distributors of the oil companies, has built up their consumer base. However, by virtue of the impugned notification, the oil companies are trying to take away of their consumer base by pre-adjusting their area of operation. Paragraph 4, learned senior counsel appearing for the petitioner further argued that the conduct of the oil companies is causing serious prejudice to the distributors, as they had invested money and worked hard to build the consumer base over the years. In course of his argument, learned counsel for the petitioners further referred to the judgment of different high courts wherein such circular was challenged, and the same has been quashed by different high courts. Taking into consideration the issue involved in the present writ petition, this court is of the view that the matter requires further hearing in presence of all the opposite parties' oil companies. Accordingly, issue notice on the question of admission to the opposite parties. Since Mr. Such and Such, learned senior government counsel, accepts notice on behalf of OP number 1, Union of India, a copy of the brief be served on him within 3 working days hence. Para 8, requisites for issuance of notice to the opposite parties by registered post with AD to be filed within a week hence. Para 9, counter affidavit, if any, be filed within 4 weeks hence, after serving a copy thereof in advance on the learned counsel for the petitioners. Para 10 lists this case in such and such, 18th August, which has not yet come. Kindly see paragraph 14, which is the operative part. As an interim measure, it is directed that the operation of circular dated 21st February 2025 under Annexure 6 to the writ petition shall be kept in abeyance till the next date. So this is under stay. Well, at the next judgment or the next order which I seek to rely on, my lord, is of the Andhra Pradesh Court, my lord, High Court at Amravati. The initial order, there are 2 orders which have been passed. One has basically extended the interim order. The first initial interim order, my lord, was passed on 28th March 2025. The date is mentioned right at the top. Kindly, my lord, take the second page of this order and the second paragraph from the top. The above writ petition is filed challenging the policy on customer transfer, market restructure. Lordship has the second page. Towards the top, my lord, the second paragraph. This is the Andhra Pradesh order. Well, the second paragraph, the above writ petition is filed challenging. Yes. My lord, the above writ petition is filed challenging the policy on customer transfer, market restructuring, and policy dated 21st February 2025. Learned Standing Counsel would contend that earlier the policy was introduced by the oil market companies in 2018, and the same was under challenge before the different high courts. The High Court of Bombay set aside the said policy by order dated 30th September 2019 in WP number such and such. Aggrieved by the same, the oil marketing companies filed SLP number such and such before the Honorable Apex Court, and the same is pending. Pending the SLP, the present policy was promulgated. Shri O. Manohar Reddy, learned senior counsel appearing for HPCL, brought to the notice of this court that the 2018 policy is under challenge before this court, wherein the learned single judge of this court upheld the policy by order dated 20th October 2024 in WP number such and such. Against the said order, the agencies preferred an intra-court appeal, YWA number such and batch, wherein the division bench of this court granted interim order on 12th December 2024 is extracted herewith. In the meantime, the consumers of LPG be not ported from the existing distributors who are before us unless they specifically make a request in that regard in accordance with the conditions governing portability from one distributor to another. During the hearing, it was brought to the notice of this court that the policy which is under challenge before the Bombay High Court in WP number such and batch, an interim stay was granted on 26th March 2025. Whether this has already been placed by Mr. Shahare. Well, I will kindly turn to the last page. Learned Standing Counsel appearing for respondents would submit that a counter affidavit will be filed within 1 week. Whether the policy on customer transfer, market restructuring, and policy dated 21st February 2025 issued by oil marketing companies dated 21st February 2025 imposing cap and transfer of existing customers to one agency to another agency violates Article 14, 19, and 300A of the Constitution of India, requires consideration after filing of counter affidavit, number the operative part, keeping in view of the interim order granted by the division bench if this court in WP number such and such, both parties shall maintain status quo existing as on today in pursuance of policy for 3 weeks. List the matter on such and such date. My lord, the matter came up again before the same court, my lord. This is the order which has been passed. 16th June 2025. My lord, I'll not trouble your lordship with the entirety, my lord. Kindly turn to the third page, my lord. the very last sentence, interim order granted earlier is extended. Lordship has that, my lord? The third
Yes.
interim order granted earlier is extended. So now this is the status before the Andhra Pradesh High Court, my lord. Similarly, my lord, this matter also came up before the Kerala High Court. My lord, the learned lawyer appearing for the HPCL has relied on various Kerala High Court judgments. So I also thought it fit and appropriate to refer to a Kerala High Court judgment wherein this circular has been stayed. My lord, will kindly take this Kerala High Court judgment as well, or order. Take to Devin. My lord, this is a lengthy judgment, my lord. I will not take your lordship through the entirety, my lord. Matter had gone before the single bench first, where no interim order was given. Then the matter came up before the division bench, which is the order I've placed before your lordship. My lord will kindly take, my lord, page number 8, the second last page of this order.
Yes.
And paragraph 6 and 7. Lordship has para 6. The opening line of the policy dated 21st February 2025 reveals that the Ministry of Petroleum had revisited the clauses as mentioned above of the 2018 policy, which was subject matter of challenge in the erstwhile litigation, and again had brought the existing LPG distributors under the umbrella, whereas the guidelines issued in 2016 still remain in vogue and have not undergone any sea change. Therefore, under the garb of those clauses, the existing distributors cannot be disturbed, violative of Articles 19 and 300 capital A of the Constitution of India. Paragraph 7, considering the attenuating circumstances and far as the conditions of interim stay, that is prima facie, balance of convenience, as also following the interim orders passed by various high courts, we order that during the pendency of writ petition, clause number such and such of the policy shall remain under stay. Writ appeal stands disposed of. It is made clear that the aforesaid view is a prima facie one, shall not constitute to be an expression of opinion regarding the pendency of the writ petition. We are sanguine of the fact that the counsel representing the parties will take effect to get the pending writ petition decided as expeditiously as possible. So my lord has therefore seen, my lord, that at the various high courts all across the country, my lord, which have already granted stay of operation of this impugned circular dated 21st February 2025, and largely, my lord, they are premised on the fact of the Bombay High Court judgment, which went up to the Supreme Court, is pending before the Supreme Court, and there is no stay of operation. And my lord has also seen the two circulars which has been placed before your lordship. There is really no difference between the two. So whatever arguments were made in respect of the 2018 circular, those same arguments which your lordship has considered will have to be made in respect of the 2025 circular as well. In other words, what is happening, my lord, a distributor who's successful, who is developing business, investing more and more money at the behest of the oil companies, they are now sought to be punished. You do well, very well, you've done well. I will now take over your customers and give them to somebody else. That is, my lord, the height of arbitrariness. These are my respectful submissions, my lord.
Yes, Mr. Nath.
My learned friend for the other oil company has submitted most of the
Yes.
addressed most of the issues, my lord. The only there are certain points which I would like to add, my lord, and may place certain clauses of the agreement first, my lord. The agreement starts at page 33, my lord, of the writ petition. My lord, kindly consider one aspect, my lord. Although there is a policy of is under challenge. However, the only right that the writ petitioner is getting to challenge the policy is the agreement, is the contract. Contract is the basis wherefrom the distributor is getting a right to approach this honorable court challenging a particular policy.
Yes.
So basis is the contract. Now kindly see what are the rights which a distributor has under the contract. this has been placed, the similar clause has been placed at page 34, clause number BII. The corporation reserves the right without any reference to or consent of the distributor to appoint one or more additional distributors in the same territory referred in clause number such and such. And as such, additional distributor or distributor shall be entitled to make sales of Bharat Gas in the, like, kindly pointed out, my lord, sales of Bharat Gas. The product belongs to the oil company. So the agreement, the contract is for sale of the product. Product belongs to the oil company. The distributor is only an agent, selling agent of the product belonging to the oil company. Now, in the same territory without any objection from the distributor, and the distributor shall not be entitled to claim any overriding remuneration, commissions, or allowance. So from this clause, it is very much clear that the product which is to be sold under this contract is a product belonging to the oil company.
Yes.
Oil company has merely appointed an agent, a selling agent, to sell the product. Therefore, the customer, the entire submission is based on a issue that the customer belongs to the distributor. It's not correct. In my humble submission, it's not correct. This is the crux of the argument. The customer belongs to the distributor. Your losses have also shown, we have all seen the LPG books, the LPG connections that we all have in our home. The book, it's the oil company. Book is issued by the oil company. The customer belongs to the oil company. Customer is not of the distributor. Customer is the oil company, belongs to the oil company. Only in that, who is the distributor concerned to make the refilling, the name of the distributor is given. So the distributor, the customer is of the oil company. So it is always within the domain of the oil company to direct his customer, its customer, to take refill from any of the distributor.
No, the issue is that customer is not of the oil company, not of the distributors. Customer is taking benefit directly from the state. This is the essential commodities.
Right, my lord.
You marketing company cannot claim that this is my customer. So this is the right of the citizens to get the essential commodities.
My lord, but
And
as a
you are the beneficiary, you are the intermediaries. You are being the oil company, being the distributor. All of the
this is not a product.
intermediaries.
This is not a product. It must be an essential commodity, but it is not a product which has been distributed under PDS. This is not a product which is distributed under public distribution system.
I understand.
So different oil companies have their own customers.
Yes.
Today, it's not a particular customer can't get a cylinder of his choice from any of the oil companies of his choice. So definitely the customer belongs to the oil company. Maybe this is an essential product.
Yes.
Only under the Petroleum Act and rules, only the oil marketing companies have been granted license to deal with this product. Been an essential product, essential commodity, but it's not been distributed under public distributor system.
Okay.
Now, so the entire argument is based on an argument that the customer belongs to the distributor. In my humble submission, the customer is not of the distributor. The customer is of the oil company.
Yes.
Now, can you see the other clauses of the agreement? Page 35, clause III. The next page, my lord. Without prejudice to the above, the corporation shall also be entitled to require the distributor to effect minimum sales of Bharat Gas in accordance with the policy that may be formulated from time to time by the corporation and shall be further entitled at its sole discretion to reduce, restrict, or alter the area of the distributorship territory, and the decision of the corporation shall be binding on the distributor. The corporation shall further be entitled to notify without any legal obligations to do so from time to time to the distributor in writing the minimum number of LPG filled cylinders which the distributor shall be required to uplift in each month. The corporation shall also be entitled to require the distributor to maintain during the duration of the agreement such minimum stock as to meet the customer's requirement. Then the next clause, my lord. The distributor will, during the continuance of this agreement, confine himself to effect the sales in the area or territory specified herein above, but the corporation shall be entitled, without the consent of the distributor, to enlarge, reduce, increase, or modify such area or territory to such other place as may from time to time be authorized by the corporation in writing. Kindly consider one aspect, my lord. The area, if there is a curtailment in the concerned area, suppose a particular distributor is given a particular area to cater the customer, it is always open for the oil company to appoint another distributor in the same area.
Yes.
So in case another distributor is appointed in the same area, then of course there will be a curtailment in the existing customers.
How?
Because it will ultimately the customer is belongs to the oil company. So if oil company to maintain,
Where is the provision? Not the, I don't want the, I want the clear provision. Clear
my lord,
provision
I
in the-
will show the manual. Kindly appreciate, my lord. I will also show the other clause from the agreement which says that all the instructions, all the guidelines,
Is there.
all the manuals apart from statutes are binding on the distributor. That particular clause is not under challenge in the writ petition. That particular clause of the contract is not under challenge in the writ petition. May I show that particular clause, my lord, once?
Yes.
Clause number 11 at page 37.
Yes.
The distributor shall faithfully and diligently observe and carry out all directions, orders, terms and conditions as may be issued by the corporation from time to time. So includes directions, orders, terms and conditions as may be issued by the corporation time to time and as may be contained in the corporation's LPG manual. Kindly, the manual has been specifically mentioned here, been binding.
Yes.
And any amendments or modification and may be made by the corporation thereto from time to time. The distributor hereby confirms that he has received the copy of the LPG manual and the general directions as circulated by the corporation on the date of this agreement and agrees to abide by and perform the same. Now, will also kindly consider, today there is a policy. Even I don't rely on the policy, even if the corporation doesn't rely on the policy based on the manual, also the corporation has the right to do so. I will show the manual. The manual is not under challenge. In the repetition, this LPG manual is not under challenge. So I have been the oil company has a right to enforce the manual.
If the oil company intends to use their right through the manual, why they issued the guideline?
But this guideline is based on the ministry's policy. Kindly see this circular. Kindly see the circular once, my lord. It is at page 47.
47.
Page 47.
Yes.
Kindly says the last policy on marketing restructuring was communicated via circulars, reference number such and such. This is referring to the 2018 earlier circular by IOCL, BPCL, and HPCL respectively. Now kindly consider the next paragraph. Further, MOP, Ministry of Petroleum and Natural Gas. MOP has approved the following changes in clause number such and such under the notes unified selection guidelines. Because unified selection guideline is the guideline based on which the selections, the appointments are made. Your losses have considered the selection process also. In there, the appointments are made on the basis of unified selection guidelines.
Yes.
So there has been a change in that manual, that selection guideline also. So this is based on the directives of the ministry. And so it's not, and so it is been followed by all the oil marketing companies. So this is a matter of policy. So even if we do not rely, even if the oil company does not rely on this policy under the manual, the oil company has a right to curtail. I will show the manual, my lord. Today the manual is not under challenge.
Yes.
Your losses have considered several judgments which have been referred on behalf of the distributors passed by different high courts. In none of the judgments, the manual was considered. And the contract makes it specifically binding, the manual binding on the distributor. Now, may I paste the particular portion of the manual? And in clause 11 of the distributorship agreement, it refers to LPG gas manual. And this is the LPG gas manual which has been referred in the contract.
Yes.
Can you rely on something without?
It's referred in your contract. It must have a copy.
It's not with me. You've not got it on record. So you would be fair that you give me a copy.
No, I will give you. I will certainly give you. I don't have a copy right now. I will give.
Page.
It's a page. No, I have given.
I've given you my job.
Sir, unreported judgments. 61.
It's not with me. Report is not report.
No, this client must have this guideline. On internal page 61 of the manual.
Yes.
Well, kindly sees the jurisdiction of the distributor. Top.
Yes.
Now, first it deals with the area. The distributor may enroll customers only within the area allotted to him by the corporation as per the distributorship agreement or approved by the corporation in writing. Even within this area, enrollment may from time to time be restricted to specified places or areas by the corporation. The distributors may therefore not enroll customers at any place without the corporation's specific clearance. So even for enrollment also, kindly consider enrollment also, consent of the WAL company is required, because after all the customers belong to the WAL company. Now kindly see the type of customer. The domestic distributor may enroll domestic and commercial customers only within brackets C such and such. However, on the recommendation of the WAL corporations, industrial customers for the packs cylinders may be enrolled. Then surrender of area stroke customers and ceiling limits. The distributor should surrender when asked for by the corporation.
Yes.
Such all those areas stroke customers. So both areas also, areas as well as customers, as demanded by the corporation on consideration of viability, refill cell limits for effecting better customer service, etc. So considering the viability, the refilling cell limit, and also better service to the customer, considering all these issues, if the corporation directs the particular distributor to surrender a particular area or to surrender customers, the distributor is bound to comply with that. So even under the manual also, which has been specifically referred in the contract, the WAL company has a right to tag its, I will use the word its its customer, WAL marketing the WAL marketing company's customer to some other distributor. The customer is not of the distributor. The customer is of the WAL marketing company.
Yes, proceed.
Now here also the ceiling limits and everything are also indicated here. Now kindly see after the table, in order to ensure that the distributors operate within the defined ceiling limits as identified above, whenever new proposals are established, customers in the extent to bring the old distributor within the ceiling limits as directed by the WAL corporation will be transferred to the new distributor. So if there is a direction for transfer of distributor from one distributor to some other, from an old existing distributor to a new appointed distributor, even that direction is also binding on the distributor as per the manual.
Yes.
Now below that, sub distributor, there is a provision for appointment sub. The distributor is not allowed to operate with sub distributors, but those are already in existence with continue till they are upgraded as full-fledged distributors or terminated after due notice. Now kindly consider the aspect like how the sale is happening. Sale of gas, because I have pointed out that the customer is of the WAL company, not of the distributor.
Yes.
The product belongs to the WAL company, not of the distributor. The distributor sells gas to the customer on behalf of the corporation. So it's only an agent to sell on behalf of the corporation. Therefore, the distributor is of the corporation. The customer, sorry, the customer is of the corporation. And as distributor of the corporation, refer distributorship agreement.
So this is the clause you are want to
Yes,
refer.
because even if we don't rely on the policy, the oil company, the oil company has a right and under the manual to direct the distributor to shift some of the existing customers to another distributor, or take away certain customers of the existing distributor and tag those customers with some other distributor. Considering certain issues like the viability, then cell limits, refill cell ceiling limits, and better service to the customers. So considering those issues, if the oil company decides that certain customers from a particular distributor has to be shifted to another customer, corporation has a right under the manual to do so, and such directions are also binding on the oil company as per the contract. Admittedly, the clause 11 of the contract is not under challenge. This particular manual is not under challenge. There are another manual which my learned friend for HPCL has referred, my lord. Even in that manual, if you can consider clause number 4.7, it also that manual is also binding on 3 oil companies. If you also see the front page,
Are
all
they
the
different?
yes, it's different. It's named as LPG manual. The one that I have shown, my lord, that is LPG gas manual. Gas manual. And LPG gas manual is the manual which has been referred in the contract in clause number 11.
Yes.
Now, clause number 4.7, internal page 57. Internal page 57 of this.
Yes.
Now, clause number 4.6. As per the OMC's direction, the distributor is required to transfer the customers to inter-company basis in line of the prevailing policy decision. Suppose, my lord, so far as the writ petitioner is this writ petition is concerned, he is a distributor of Bharat Petroleum Corporation. Now, if there is a direction, a decision taken to transfer that particular customer, the customers of the distributor of Bharat Petroleum to be transferred to a different oil company, even that is also permissible.
Yes.
So it's not about from one distributor of one particular oil company to another distributor of the same oil company, but it can be done to a distributor of a different oil company also. So that is also permissible. Hmm? Even 4.7 kindly sees, it says the customer is enrolled, because I have also seen the manual, from that manual also, it's on behalf of the well company. So the customer is of the well company. The customer is enrolled by the distributor on behalf of OMC. Now, internal page 84, clause number 10.5.
Yes, portability.
So even the customer is also given a choice. Today, a distributor is saying, you can't take away my customer. It's my customer. It's my customer. You can't take away my customer. But that can't be the right. Even the customer has a choice. Not even the wire company. Even the customer has a choice to move to a different distributor. Losses also knows that the age-old principle, my lord, a competitor in trade, the only issue is I will lose my business. That is the only issue. 19(1)(g). Article 19(1)(g) is the only issue. Now, a competitor in trade cannot take the plea of violation of Article 19(1)(g). Yes. Another information, Manal, I like to place, Manal, so far as the earlier circular is concerned of 2018, all the judgments and everything which were being relied are based on the 2018 circular. The only point of argument is that has been struck down. That has been struck down by the Honorable Bombay High Court, and so it has an effect all over India, and it has yet to be disturbed by the Honorable Supreme Court. That is the whole contention. Even the judgment that your losses has passed in February, my lord, referring to the earlier circular. Certain issues, your losses are considered certain issues. One is, since that particular circular has already been struck down by a different high court, so it is no more applicable even in this state of West Bengal also. That was one issue. And the challenge against that order is pending before the Honorable Supreme Court, and there is no stay. During pendency of that SLP, now the SLP has recently been admitted. It has now become a civil appeal. In appeal, there is an admission. So now it has become a civil appeal. So even before Supreme Court also, submissions were made seeking leave to come up with this new policy. That submission was also made before the Supreme Court. So new policy is also within the knowledge of the Honorable Supreme Court, which has come now. Now there are certain changes in the new policy. It's not that the earlier policy had been reintroduced. It is not the earlier policy has been.
This is the submission from the petitioners.
Yes, it has not been reintroduced. There are certain changes where if there are certain changes in the policy, it can't be said the earlier policy has been reintroduced. Now the most vital change in the new policy is the viability. Suppose earlier it was that if he has a customer base, that will be curtailed. Now 100% of existing customer that has been protected.
But you have diminished the limit.
Yes.
Earlier it was limit was 20,000. Now you have turned it into 10,000.
Let-
Make it 100% instead of 75%. So
So-
what is changed?
So because unless earlier it was a curtailment of the ceiling limit, now instead of 100%, it was curtailed to 75%. Now it has been made to 100.
75%. Now it is 100%. So the viability limit is now 100%. So you cannot say, no one can say that your viability limit is intact. It is 100%.
Earlier it was
It was
different.
70%. But what you have done, that the earlier ceiling limit was 20,000. Now you have changed it to 10,000. That means if your ceiling limit is 10,000 now, so if it is now 100%, now ceiling limit is 10,000, not 20,000 as it was earlier. So what changed now? I want to know.
Well, the ceiling limit and the viability, these two things are different. You will also see in the manual at page 61, that difference is given. Even you see the manual also.
Ceiling limit of cylinders, which one distributor can operate in a month, like that.
Even it is given in the manual also. It's a part of the contract.
Yes. There may be a ceiling limit of each distributor.
No kind.
Respect of their location where it is performing the business.
Now, here, unlike the earlier, the other repetitions which you losses are considered, here, kindly sees the prayers also.
In this repetition?
Yes.
Challenge the circular. Yes.
The first now in the read the mandamus which were sought for is the circular.
Yes, circular. Circular February 21, 2020.
Kindly appreciate there was an curtailment of distributors based not on based on the manual, based on the circular of 2018. The read petitioner has not challenged when 2018 circular was there and there was a curtailment of 2000 based on the 2018 circular, that was not challenged
By this petition.
by this petition. Now, kindly sees without there is no prayer seeking any mandamus so far as curtailment is concerned.
Now, whether you have any order is there, any letter is there regarding
No,
curtailment?
there is
Such
nothing in the
order is there.
the read petition. There is no such letter.
No such challenge is there.
No, there is no such.
In this petition, there is no such.
Kindly
Earlier
sees
petition,
prayer
there are
now kindly sees prayer H.
prayer H.
Yes. An order declaring that any effect given by the respondent number 2 to the circulars dated 4 January 2018 and 2010 January 2018, including by way of transferring 1918 customers on June 20, 2025 and 4069 customers on 11 September 2018. Now kindly see curtailment done based on the earlier circular in September 2019
Sought
is
to be declared,
sought to be challenged in July 2025. And there is no no mandamus has been sought for. It is only by of an interim order. Now there is, if there is no pleading to that effect also, may I correct?
Now I understand. Mr. Nag, what is your submission now regarding interim order? As they.
My lord, kindly sis, if your losses, stay the operation of the circular, stay the operation of the circular. Your losses may kindly clarify that I have a right. The oil company has a right, whatever right that the oil company has a right to exercise under the manual,
Through the manual also, the oil company has the right.
right? And that manual is not under challenge. Your losses may clarify that.
Okay, okay, okay. Okay. Yes,
May I
in
reply, sir?
reply,
Yes. My lord, the first argument which my learned friend.
I will only like to place two judgments where the scope of judicial review, so far as policy decision is concerned, there is a
then
restriction.
it would be continued tomorrow. Otherwise, I have second half other matter is there.
Well,
I have
ma'am,
division
I
bench.
will only take 5 minutes to show something.
Tomorrow 10:30. Tomorrow continue 10:30, all the matters.
Item number 9, my lord, it is appearing. I have mentioned in the morning, interim order is going to be except tomorrow. So tomorrow your lordship is normally takes up the group 8 matters. My lord,
Group 1 matters. Let it appear on tomorrow at top. No,
Tomorrow.
this matter will be taken.
Tomorrow at 2 p.m. my lord.
Original said,
Origin side is there.
10:30,
No.
prior to this matter.
Prior to this matter.
Then my lord kindly take it up on Friday.
The
Friday.
interim order will going to expire tomorrow. That's my issue.
Because
And we
Mr.
have
Doctor
that
has
same-
some difficulty tomorrow morning.
Tomorrow morning you have difficulty. Then come on 2 p.m. Tomorrow 2 p.m. before ordinary side I will take up the matter.
Fine.
Item number
9.
9. This matter continue. Okay. Calculate
Item 327.
Item number. These are item numbers.
9.
No. I am hearing these matters. Item number 11, 12, 13 and 14.
My lord.
Argument on behalf of the parties continue. Let the matter appear tomorrow under the same heading.
হাজার 800 তার উপর যেটা বেস করে করেছে সেটার জন্য আমার ফিলিং এর দরকার কি আছে? ফটোটাই চলে যাবে। আর আমারটা তো আপনি এটা তো এক করতে পারবেন। You hope the position of law. which is
Item
instructed.
327.
So result.
Fixed at
Judgment just the foundation post.
Number 9, tomorrow 2 p.m.
327 are fixed at 12:30. Cannot be taken up today. Tomorrow same time because very short point is involved.
Tomorrow I have a group 1 determination. It will appear Monday.
Monday. Time marked as 12:30 because today it is 12:30.
As it was there, it will be appeared.
So tomorrow morning these 4 matters all for sometimes and
Yes.
at 2 p.m. my item 9.
Yes.
Grateful, my lord.
Get
Stop writing.